Dear friends, welcome again in next episode on the summary of the show cause notice DRC01. Whenever any DRC01 or DRC01A is issued to any taxpayer, there are certain grounds, certain points which are the reason before the proper officer to believe before issuing you the DRC01. Broadly, these are three main grounds for issuing the SCN by the proper officer to any person. Number one is tax not paid or short paid, tax erroneously refunded, input tax credit wrongly availed or utilized. These come under section 73 and 72. Section 73 when it is non-intentional and 74 when it is intentional or willful fraud commitment. Along with SCN, the proper officer will also issue a summary of SCN form DRC01 having following details. Along with the SCN, the proper officer will also issue the summary of SCN. The details which contain the following informations, which are details of person to whom SCN is to be issued like GST, address, contact details, tax period, assessment year, financial year, section under which the SCN is proposed, SCN reference number, case ID number, if it is supplied, if it is uploaded on the common portal, which is mandatory also as per the instruction issued by the GST CBIC in 2019. Then the brief facts of the case. Brief facts of the case has to be communicated to the taxpayer as why he is being issued the show cause notice. Then the grounds of issuing the show cause notice. The grounds of the show cause notice has to be framed by the proper officer after conducting the thorough inquiry and investigations. The thorough inquiry and investigation is very essential part of issuing any SCN and making any ascertainment of the liability against the taxpayer. Otherwise, the cases cannot be upheld against the taxpayer in the further scrutiny of law before the appellate authorities or before the higher apex appellate channels. Therefore, the success of the SCN, the success of the final order DRC07 depends upon the how intelligently the show cause notice has been prepared by the proper officer and what are the reliable grounds mentioned therein in the show cause notice. The grounds must be supported by the credible and reliable evidences. Without the credible evidences and reliable evidences, the show cause notice becomes a hollow notice. Therefore, the grounds of any show cause notice is the soul of the entire case. The show cause notice is a separate subject, detailed subject on which I will deliver a separate episode on some other day, which is under preparation so far with me. But in this episode, it is important to mention that the grounds of the show cause notice must be drafted carefully, intelligently, and after conducting the thorough inquiry, probe, and investigation, and collecting the credible and reliable evidences against whom the SCN is proposed. Then, in the last, a table should be formulated depicting therein the year-wise amount of the turnover, taxable turnover involved, amount of tax, IGST, CGST or SGST wise, interest leviable and penalty amount proposed. Then comes the time limit to issue SCN, summary of SCN DRC01. Time limit to issue SCN, summary of SCN DRC01. In case of bona fide defaulter, 2 years plus 9 months from due date of filing of annual return of relevant financial year. Dear friend, there is a wide misunderstanding, confusion, state of non-confidence among the various stakeholders about the very particular points of the GST Act. One of which is time limit to issue the SCN, summary of SCN or DRC01. In case of bona fide defaulter, there is a time limit of 2 years plus 9 months from the due date of filing of annual return of relevant financial year. In case of mala fide defaulter, bona fide defaulter is taken under section 73, whereas there is no element of intentional evasion. And in case of mala fide defaulter, which is an intentional fraud, attempt of intention of evasion, cases of fraud and suspension, there is 4 years plus 6 months from the due date of filing of annual return of relevant financial year. Dear friends, everyone is surprised at why this much time, 3 years and 5 years time has been allowed. Dear friends, in my entire service, my 70% service has remained with the enforcement during my career. The successful enforcement depends upon the intelligent investigation and inquiry. Where the investigation and inquiries, the element of investigation and inquiry comes into play, this is a time-taking exercise. There are certain privileges, fundamental rights available to the taxpayer under the GST law or under the common law of the land, which have to be respected. Otherwise, the taxpayer resorts to the unnecessary litigation to seek respite from the judiciary, and this will again prolong this period. Therefore, the legislature has provided sufficient time for 3 and 5 years. And the second reason for allowing this much time is because in GST system, the ITC chain is pan-India. The investigation of any taxpayer, of any state, of any jurisdiction is a two-way is a cross verification. If I am certifying if you are satisfied with the version given by taxpayer stationed in district Solon, that cannot be admitted until or unless it is cross-verified by the proper officer of the supplier. Under the Evidence Act, the cross-verification or the certificate provided by the proper officer of the supplier is admissible only. There are taxpayers who always assert before the authorities, adjudication officers, that we have these much evidences. We have the tax invoice, we have the credit notes, we have the payment history, we have the eBay bills, we are having the goods receipt, vehicle driver photo, and so many evidences to prove that their transactions are, their purchases are genuine. And same story can be repeated by the suppliers too, because supplier and the recipient both are a private persons. In that case, the department or the law of the land puts the onus on the government authority, and means on the proper officer. It is a proper officer of the another state. Suppose in about in 50% cases the purchases of the HP taxpayers are from New Delhi. Therefore, the New Delhi proper officer are bound to give the assist the officers of the state of HP whenever inquiry or any verification or cross verification or information is sought from those officers. Under the GST Act, all the officers are bound to assist. Friends, under the state laws, this is the major impediment before the state officer, that they are restricted up to their jurisdiction. They are restricted to their jurisdictions. In exceptional cases or practically, it is not possible to visit for every investigation in other states, because in one case, in one taxpayer case, there may be 2, 3, 4, 5 dozens involved suppliers, and the major impediment before the state officer is the manpower, that they don't have manpower, they don't have such sufficient resources to deploy their officer interstate, and there are the security reasons also connected with them. Therefore, the common portal and the act provides for the verification or cross verification through the common portal or the email or by letter, and such verification, cross verifications are given by the proper officer of other states, and similar of the within state tax proper officer also supplies such cross verifications or inquiry reports whenever sought about such suppliers. Therefore, this time limit of 3 and 5 years has been allowed. The summary of statement DRC02. We were discussing DRC01, summary of show cause notice SN. Now we will discuss summary of statement DRC02. If a proper officer under GST want to issue SN on same grounds as specified in earlier issued DRC01 for additional periods than as specified, he may do so by serving statement under DRC02 for any of the following reason. Same reason: tax not paid, short paid, tax erroneously refunded, input tax creditor wrongly paid, utilized, Along with statement, he shall issue a summary of statement in Form DRC02 having following details. Details of person to whom SCN is to be issued, like GSTN address, taxpayer, financial year, section reference, SCN reference, case ID, brief facts of the case, grounds of statement, taxes and other dues, interest penalty and others. Then DRC03, payment made voluntarily or made against the show cause notice DRC03. A person to whom notice has been issued in Form DRC01 or DRC02, he can make payment and intimate to proper officer in Form DRC03 within 30 days from the date of issuance of such notice. This is the third step. After receiving DRC01 or DRC02 from the proper officer, the taxpayer has to reply, has to respond back in the form of DRC03. A person to whom notice has been issued in form DRC01 or DRC02 can make payment and intimate proper officer in form DRC03 within 30 days from the date of issuance of such notice. A person can also make payment before issuance of SCN on a voluntary basis and intimate to proper officer in form DRC03. The following details are required in this form. DRC03 is a prescribed form. Therefore, the following details can be discussed: GSTN and name, cause of payment, voluntary SCN, section under which payment is made, 73 or 74, reference number, case ID of SCN issued in DRC01, DRC02, DRC01A, financial year, tax period and act, payment details including interest, penalty and others, and the reference number of the notice DRC01A 0102 has to be mentioned specifically on the DRC03 so that it is well acknowledged by the proper officer. Then acknowledgement in the form DRC04, where a person has made voluntary payment of taxes, interest or other dues in form DRC03 before issuance of open notice and a proper officer is satisfied with the intimation of payment, amount and a reason stated for making payment, then the proper officer shall issue acknowledgement in form DRC04. Then comes the conclusion of proceeding DRC05, where person has made payment of taxes, interest and other dues in form DRC03 in 30 days of issuance show cause notice, statement in DRC form DRC01 or form DRC2 and the proper office satisfied with intimation of payment of tax and other dues against such notice, then the officer shall issue an order in form DRC05 specifying about the conclusion of proceeding in respect of such notice. Reply to a show cause notice DRC06. If the DRC01A, 2, 1 or 2 are not accepted, then he will reply in the form of DRC06 to the proper officer, mentioning therein the as in detail reply to the SCN documents uploaded, if any, an option of personal hearing. Summary of DRC07, where a show cause notice from DRC01 or statement DRC02 has been issued by proper officer and the concerned person has not made the payment in DRC03 or made short payment in form DRC03 or not given explanatory satisfactory explanation form DRC06 and not taken any action. Here DRC07 is very important to note. If when a no show cause notice in form DRC01 or a statement in DRC02 has been issued by the proper officer and the concerned person has not made the payment in form DRC03, made short payment in form DRC03 or not given explanation, satisfactory explanation in the form DRC06 or not taken any action, in these circumstances the proper officer shall issue an order in form DRC07 stating the amount of demand and due date for making the payment of taxes along with interest and penalty. The details to be mentioned in DRC07 will be GSTN and name of the taxpayer, order number, date, tax period, issues involved, description of goods, services, details of demand. Form DRC07 issued in other circumstances as well. To know them, DRC07 is issued in other circumstances also. Summary of order DRC07. Form DRC-07 can also be issued in the following circumstances: when any person transports any goods, supplies or receives goods with an intent to evade the tax, transports any goods or stores any goods while they are in transit in contravention of the applicable law. Number 2, supplies or receives of goods with an intent to evade the tax, does not account for goods on which liability of tax is, supplies goods liable to tax without taking registration, contravenes any provision with an intent to evade the tax, uses any convenience for transportation of goods in contravention of law, and where no penalty is separately provided for contravention of any provision of law, time limit to issue order in form DRC-07 are, in case of bona fide non-intentional taxpayers, tax evaders, is 3 years from the date of filing final return on the relevant financial year. In case of bona fide defaulter, in case of fraud or willful defaulter, it is 5 years from the date of filing final return on the financial year. In case of person pays tax, interest and penalty equivalent 50% such tax within 30 days of communication of such order, all proceedings to said notice shall be deemed to be concluded. In other words, 50% penalty waiver is paid within 30 days. Rectification order DRC-02, where it comes to the notice of the proper officer on its own motion by any other person, by the affected person within 3 months from the date of issue order regarding some error which are apparent on the face of an issued order, then the proper officer make rectification of such order from DRC-08. DRC-08 should contain particular original order, reason for rectification, demand, details of demand, if any, after rectification. Other points, the rectification order has to be done within a period of 6 months from the date of issue of such order. The period of 6 months shall not apply where application is purely in nature of correction of clerical or civil error. When such rectification affects the person adversely, principle of natural justice, opportunity being heard, shall be allowed. Order of recovery DRC-09. Where any person to whom any order with amount payable had been issued fails to pay the liability within 3 months from the date of service such order, the recovery proceeding shall be initiated. The time period can be less than 3 months in some special circumstances if it is expedient in the interest of government revenue. The proper officer may require any specified officer to deduct the amount so payable from any money owing to such defaulter for recovery of dues in form DRC-09. The following details are contained in form DRC-09: details of specified officer, particular defaulter, GST name, demand, ID, recovery ID, details of area and remarks if any. Notice for auction of goods DRC-10, where an amount is due from any person who failed to pay it within 3 months from the date of service order, the same is required for selling the goods belong to such person. There is a procedure. Notice to successful bidder DRC-11, then sales certificate DRC-12, certification of payment to a third person DRC-14, application requesting execution decree DRC-15, then notice for attachment DRC-16. Proper officer may also attach the following assets belonging to the person who has defaulted and issue a written order in form DRC-16. Notice for auction DRC-17. Certificate action for recovery DRC-18. Application to magistrate for recovery as fine DRC-19. Applicant deferred payment installment DRC-29. 20. The installments, if any demand, the taxpayer is interested or is desires to pay in installments or deferred payment, he can make application to the commissioner, respective commissioner, and the commissioner, after satisfying him from calling the record of the proper jurisdiction officer, may fix the installments, but it should not exceed than 24 in number. Order of acceptance and rejection of application DRC-21. The commissioner, while making the application of the taxpayer for fixing installments, may accept or reject his application, and that order has to be communicated back to the taxpayer in the form of DRC-21. Provisional attachment DRC-22. This is the most important, most hot subject of the GST system so far, and many litigations has been centered around this provisional attachment. Where due the pendency of proceeding on a person due to any of the following reason: assessment of non-filed returns, assessment of unregistered person, summary assessment in certain special cases, inspection, search and seizure, bona fide and mala fide defaulter of tax. Then if the commissioner or the officer authorized by him is of opinion for protecting the interest of government revenue, he may issue an order in form DRC 22 to provisionally attach the property, movable or immovable, including bank accounts belonging to a taxable person. The provisional attachment is effective for 1 year from the date of issue of the order in form DRC 22. The restoration of provisional attachment DRC 23. Where any order has been passed in form of DRC 22 to provisionally attach the property, movable or immovable, including bank accounts belonging to tax person, then the same can be restored by the commissioner or by the officer authorized by him by passing an order in form DRC 23 on any following reason. The property attached is of perishable nature and the taxable person pays an amount equal to the market price of property or the amount which may become payable on such property whichever is low. Number 2, if the concerned person files for objection within 7 days from the date of order issued from DRC 22 to the fact that property is not liable to attachment. If the commissioner, upon being satisfied that the property is no longer liable for attachment, then he can restore this provisional attachment in the form DRC 23. Intimate to liquidator, where any company is being bound up under the orders of a court or tribunal or otherwise, the person appointed as liquidator is required to give intimation of his appointment to the commissioner under GST laws. The commissioner within 3 months of the receipt of such communication notify the liquidator for the recovery of an amount representing tax, interest, penalty or any other amount due in form DRC 24 which are or may become payable by the said company. Continuation of recovery proceeding DRC 25, where government dues, tax, penalty, interest or any amount payable are enhanced in appeal, revision or any other proceeding, the taxable person shall be served with a demand notice only in respect of enhanced amount. The commissioner shall issue an order in form DRC 25 for the recovery for enhanced amount along with existing demand which stand continued from the stage existed prior to disposal of appeal, revision or any other proceeding. Where government dues are reduced in appeal, revision or any other proceeding, an intimation of reduction shall be sent to the taxable person. The commissioner shall issue an order in form DRC 25 for the recovery of reduced liabilities which stand continued from the stage as it was prior to the disposal of appeal, revision or any other proceedings. Summary of order creating demand under existing law DRC 07A. If any demand, where any demand of tax, interest, penalty, fee or any other dues which becomes recoverable consequent to proceeding initiated under existing law. 4. Commencement of the GST Act. Before and on or after the effective date of implement of GST laws, unless recovered under the existing law, can be recovered under GST law form which demand can be raised from DRC 07A. Other related points, only for demands which are recoverable, order can be issued under GST law. Only for demands which are recoverable, order can be issued under the GST laws. The demand order should mention the original demand under the existing law, the amount already paid and the balance amount recoverable under GST law. The demand created shall be posted to electronic liability register part 2 other than return related liabilities. Existing law can be state level value added tax, central excise duty, service tax, anti-tax or other acts which were subsumed under the GST Act. Amendment, modification or summary of the order creating demand under existing law DRC 08A, wherein demand of tax, interest, penalty, fee or any due was raised in DRC 07A and same is subsequently rectified and modified request due to the appeal, review, revision, recovery is made under the existing law, and an order of amendment or modification shall be issued in form DRC 08A. Therefore, we have discussed here all the DRC form, the demand and recovery forms. All these forms are uploaded or uploadable on the common portal are digital in nature. While uploading these forms on the GST portal and the case ID of the respective taxpayer, the proper officer having jurisdiction of them can upload it by the digital signature or by taking the hard copy. After scanning it is uploaded on the common portal, and when it is digitally signed, it immediately receives in the email box of the recipient. We have discussed all the DRC form here, which will give the in-depth knowledge, in-depth education to the stakeholders. And what are the DRC form? What is the full form of DRC form? And what is the purpose? And what is the use of each form? And one thing is very important, since the GST system is a time compliant system, it is onus on both the sides, taxpayer as well as on the revenue, to comply these forms in time-bound manner. With these words, I stop here. We'll meet in next episode soon. Thank you.